Alright, so this one we're going to talk about the Vernonia School District versus Acton. Alright, so this is going to be the second court case to the Module 2 case study. The last one we talked about was New Jersey versus TLO. This is Vernonia School District versus Acton. This took place in 1995. Alright, so again, here's the questions that we're going to have to answer. We do have to write 2 paragraphs, each one summarizing each case, 3 to 5 sentences for each, at the minimum. You're going to determine how these cases are similar to each other. How did the earlier case, New Jersey versus TLO, serve as a precedent for Vernonia School District? What were the main arguments for each side of the Vernonia versus Acton case? Make sure to use details to support the opinions for each side. So you're going to give the main argument for the Vernonia School District and for the Acton family. And then on the last question, you're going to give your opinion of which one you think had a stronger argument. Was it the school district or was it the Acton family? Be sure to use evidence to support your opinion into which you think had a stronger argument. Now, it doesn't matter which side you choose. Again, you can side with Acton, you can side with the school district. It does not matter. Okay, there's always going to be a dissenting opinion. That's just all they are. They're just opinions. It doesn't matter which one you choose. Just make sure that you use some evidence to support your opinion. Provide a very convincing argument. Don't just say, I don't think students should be subjected to drug testing, period. That's not convincing. Be convincing. Why is it a violation of privacy? Why does it violate your constitutional rights? So on and so forth. But enough of that. We're going to go ahead and jump into this. Okay, so what happened? What happened is there's a kid named James Acton. He went to Vernonia School District, the high school there. This is in Oregon, I believe. Don't quote me on that. But anyway, the school district, in an attempt to deter the rising drug use among the student body, the officials adopted a policy known as the Student Athlete Drug Policy. Now, this policy requires student athletes to submit to random urinalysis drug testing to make sure that they weren't using any illegal substances. Now, James Acton's parents did not consent to the testing. In order to test the students, the parents had to consent. Now, because the parents did not consent, well, guess what? James did not get to play football. So he had to miss out on that football season because his parents would not allow him to take the drug test. Now, many of you may be thinking, well, why not just take the drug test? I mean, if you're not doing drugs, just take the test and move on. Well, the parents, well, I'll get into that a little more. The parents did not, you may think that the parents were just trying to sue the school to make a quick buck. That's not necessarily the case, actually, because the Acton family actually filed a lawsuit seeking declaratory and injunctive relief, stating that the policy violated the 4th and 14th Amendment of the Constitution. Now, what is declaratory relief? Declaratory relief is basically a judgment of the court that determines the rights of each party without ordering that anything is done or that anyone is awarded damages, so that no money was being paid out here. Declaratory relief is basically where the court just decides, okay, this is where your rights begin, this is where your rights end. Okay, I'm just going to make a judgment call on this. This is what's going to happen. Now, injunctive relief is an actual court order, a court order that prohibits any kind of action. So the Acton family was looking for a court order to say, hey, school, you're not allowed to require this. He should be able to play football, period. Again, not looking for any kind of monetary compensation. They just wanted the issue to be handled. They were basically challenging the policy, probably more on a principle. They're trying to prevent the school from being able to violate the students' rights. They looked at it as a violation of constitutional rights, and they were probably really doing this more out of principle than anything, not necessarily because they were afraid their son might fail a drug test. Now, however, the district court denied the claims and sided with the school district. The school district policy was considered constitutional. Now, the case was reversed pretty quickly in the Courts of Appeal. The Courts of Appeal stated that the policy did violate not only the federal but also the state constitution. Now, this case was again appealed to the Supreme Court. Now, the Supreme Court would make the decision in this case, and let's go see what that was. Now, what is the issue first? The issue is, does random drug testing in high school of high school athletes violate the reasonable search and seizure clause of the Fourth Amendment? Does it violate the Fourth Amendment to randomly drug test high school students when they're not showing any kind of suspicion? They're not showing they're not giving off any suspicion at all that they are partaking in drugs. It's completely random. The majority opinion was decided by Acton and Scalia. He stated that when parents place minor children in public schools for their education, the teachers and administrators of those schools stand in loco parentis, which basically means is Latin for in place of the parent. And they stand in this place over the children that are entrusted to them. He also stated that the TLO case emphasized a degree of supervision and control that the state had over school children. He also said that he compared the drug testing of to other privileges that the schools had. For example, the ability to require students to submit to various physical examinations. You have to go to your doctor and get your physicals done before you can go to school. You have to get your vaccines done. So if physicals and vaccines are not a violation of a student's privacy, why is a drug test? Why is a drug test a violation of a student's privacy? So that's one point that was made in the majority opinion. But the main reason for the decision is simply the reasonableness of the search. Okay, the reasonableness of a search is considered by the balance of intrusion on an individual's Fourth Amendment against the promotion of a legitimate governmental interest. So basically, does the interest of the government outweigh the privacy or the constitutional right? Well, it does in this case. Think about an airport. When you go in and get on an airplane, you're searched, right? That's because the governmental interest outweighs your constitutional right. Okay, so that's one argument made for the majority opinion, probably the main argument. Now, this one right here, Ruth Bader Ginsburg, she agreed with Scalia. It's not too often that those two agree. They're actually very different when it comes to their belief in constitutional interpretation. But this is one area where they definitely agreed. Justice Ginsburg added that these policies, however, should only apply to students who voluntarily participate in school athletics. This should not apply to all students. It's only those who voluntarily participate in school athletics, which is a point that I think is a pretty good point. If you don't want to play football, or if you don't want to take the drug testing, well, you don't have to play football. But you do have to go to school. The government makes you go to school. They don't make you play football. So that's one way of looking at it. She does cite the Supreme Court case of U.S. versus Edwards, which stated, in contrast to searches without notice and opportunity to avoid examination, like for example, airport search of passengers and luggage is avoidable by choosing not to travel by air. You can choose to avoid those searches to get on a plane. Just don't travel by air. Get in a car. You can avoid the invasion of your privacy by having to take a drug test by just not playing football at that school. You can still play football. Go play somewhere else. Go play with someone that doesn't make you drug test. It's a free country. You can go play football after school with your friends. No drug test there. Now, the dissenting opinion was written by Justice Sandra Day O'Connor. She's the first woman Supreme Court justice here in the United States. She stated that blanket searches, because they can involve thousands or even millions of searches, pose a greater threat to liberty. They then do suspicious-based ones, which affect one person at a time. So she's saying that the blanket searches is what she has a problem with, just searching everybody. Now, if there's a suspicion, that's fine, but not a blanket random search. She then went on to say that throughout constitutional history, the courts have viewed blanket searches as unreasonable, which is very true. Since there was no suspicion that Acton was using drugs, this search is in violation of his Fourth Amendment right. So here's some things to think about. To what extent do students have a right to privacy on school grounds? And are random drug tests in schools different from maybe, say, a drug test for an adult employee? Adults have to get drug tested when they go work for a company, and they may get randomly drug tested. So how is that any different than a student in school who's being drug tested? And do you agree with Justice Ginsburg's statement about voluntary athletics? If you don't want to be drug tested, don't play sports. Do you agree with that? All right, so again, here's the questions. Make sure to write a summary of each case. Make sure to address the similarities between these cases and how one serves as a precedent for the other. Because remember, the TLO case was 10 years before the Acton case. One was in 85, one was in 95. Make sure to, in the third question, make sure to use details and evidence to support the main arguments for each side, in the school district side and also the Acton family side. And then which one do you feel has stronger argument? This should be the paragraph where you just ramble on and on and on. Give me some good, convincing arguments. And use evidence. Quote the justices. Quote the Fourth Amendment. Okay? Give me some good arguments. Right, so that's going to be it for today. If you need any more help with this, be sure to contact me. I hope this was helpful. And I'll get some more videos posted soon for the Module 3 case study.